of Emotional Perception AI Limited against Comptroller General of Patents, Designs and Trademarks.
Yes.
May it please you, my lords. I appear with my learned friend Mr. Eustace, instructed by Mr. Dealing of Hepworth Brown for the Appellant, EPAI, and my learned friends Mr. Nicholson and Ms. Edward Stewart are for the Comptroller, instructed by the Government Legal Department. My lords, you've had our written cases, and I don't propose to say much by way of introduction, and after a very short context setting, I will address the substance of matters in much the same order as I do in my written case. But the broader context is this.
Can I just say this? That the interveners are not appearing orally, but we, for our part, would certainly be assisted by concise responses to the principal points taken by the interveners. I'm not asking you to go seriously out of your way, but if you could somehow factor that in.
I'm certainly picking up a few of the points that they raise as I go through my submissions, my lord. I haven't sort of gone through seriatim to address.
No, I don't mean as if it's a pleading, but just the main key points.
So by way of context, under the Patents Act and under the European Patent Convention, the EPC, patents are to be granted for inventions which are new, which involve inventive step and which are capable of industrial application. And an invention which is new, involves inventive step and which is capable of industrial application becomes a patentable invention, and subject to any other form of requirements, a patent can be obtained for it. What lies at the heart of this appeal is the correct identification of the invention itself. That question involves a consideration of the interaction between the wording of the statute, including features from Article 27.1 of TRIPS, which requires the grant of patents in any field of technology, and the statutory exclusions, which state that certain subject matter does not constitute an invention, but subject to the important caveat that the exclusions only apply to that subject matter as such. Once the invention has been properly identified, then questions of novelty, inventive step, industrial application can be asked of that invention in the conventional way. As to ANNs themselves, these are structural machines, as the Court of Appeal described them, the function of which is determined solely by the arrangement of their internal links and nodes acting according to their weights and biases. As your lordships will have seen, an ANN can be manufactured in hardware, which is just a circuit of wires and resistors and amplifiers, or the same ANN may be emulated using a software platform. In each case, the ANN is exactly the same. It has the same structure, the same function, and produces the same outputs.
And you say it's a machine in both cases?
Indeed. At the level of an ANN, it is a machine in both cases.
That rather begs what you mean by a machine.
It does.
And why that's relevant.
Well,
is a machine a physical thing necessarily, or is it an abstract thing?
Well, in this case, it's a structure which has a particular function, and you can implement it in one of two ways. And as I come on to explain, the law of the European Patent Office draws a very clear distinction between inventions as claimed, the thing that's claimed, and the manner of implementation of that invention. So in the Vicom case, which we'll spend a little bit of time on later on, they explicitly say that an invention which is claimable, it doesn't matter if that invention is implemented in hardware or using modern technical means in the form of software on a computer.
Well, you described it as a machine. I think that's what's puzzling us.
Well, at the level of, okay, it's a structure which provides, it's a functional structure. It's a structure which provides a particular function, which structure can be implemented as hardware or emulated in a software platform.
May I also, for my part, please ask invite both counsel to be as clear as possible as to when it comes to using terminology, because we're going to be hearing contributions, inventions, technical contributions, all of these terms are going to be used and have been used in the cases and in your written cases. It may be said, well, an invention is what you find in the claim. We're concerned with it may or may not be inventive, but do we look to the claim to see what patentee or putative patentee says the invention is?
My Lord, I completely agree. It's really important to have precision in this field, and that's I'm going to come on to actually spend quite a bit of time in my submissions working through.
What you might call naming of parts.
Sorry?
What you might call naming of parts.
Well, yeah, one needs to make sure that the language is correctly understood, absolutely. Because it is really important to distinguish between the invention, the claimed invention, a patentable invention, for example. And just to pick up on those, the claimed invention, according to, as set out in Section 125 of the Act, is that which is claimed. And that may be old, it may be new, it may be excluded, it may be terribly clever. It's just that which is in the claims. The invention, as set out in Article 52 or Section 1.2, is that which is claimed, less any subject matter which is excluded as such pursuant to the exclusions. And I'll come on to address in some detail how one identifies that which is excluded. A patentable invention is that invention tested for novelty, inventive step, industrial application. And if it has those three characteristics, then it's a patentable invention. When it comes to technical contribution or technical character, the European Patent Office, and I will show you this in G119, is very clear that technical just means subject matter that is not within the exclusions, or more accurately, doesn't, let me call it broadly at that level, just subject matter which is not excluded as such. And they say that that's paragraph 32 of G119 sets that out. And the language of technical contribution or technical character, and I'll go on to explain this to you as well from VICOM and G119, is really just getting at identifying the invention in the Article 52 sense, so that which is claimed but not excluded. And I will come on to all this, and it's for this reason I am going to spend quite some time on the European law to make sure that its structure and detail and analysis is properly understood, because precision is really important, my lords. So I was, if that addresses my Lord Kitchen's point. Now, I was talking about ANNs a moment ago. Now, there's no debate, I think, that a conventional computer contains a central processing unit of memory, etc., and that a conventional program is a series of logical commands which instruct the CPU to execute a specific function. And those are the definitions that you see in our written case. And nor is there, I think, any debate that an ANN does not have those features. It is neither a computer nor contains a computer program, as they are conventionally so understood. Now, my learned friend advances a wider construction, and I'll come on to it, but just to note for now that even were that wider construction to be accepted, then there still arises an ancillary debate as to whether an ANN contains the necessary, quotes, instructions, as his construction demands for one to find a program for a computer. So even on his construction, there is a further debate which arises on the facts. The first appeal question, therefore, relates to the correct approach for identifying the invention under the statute. There's no real dispute as to how the EPO approaches this, which is set out in my written case. My learned friend doesn't criticise any of that, and nor does my learned friend suggest that the EPO's approach is wrong, or rather than a faithful and fair interpretation of those statutory provisions. There is a dispute as to whether the approaches here in the EPO necessarily lead to the same results in all cases, and I will come on to explain why we say that is not the case. And you'll also have seen from the interveners' submissions that that is their practical experience, which is that the approaches taken in the EPO and the UK lead to different results in fact. Now, we say as a matter of form and comity, this court should adopt the analysis of the EPO, irrespective of whether or not the two approaches necessarily lead to the same outcomes in all situations. But a fortiori if they do not, or if there is a risk they do not. In short, if the substance is the same, we should align on form, and if the substance is different, or there is a risk of difference, then we really must align both substance and form. The second appeal question concerns a meaning of programme for a computer under the Act. And as I said, the Comptroller accepts that our proposed construction correctly describes what my learned friend calls a conventional computer and conventional programme. He says that like that's a bad thing. To the contrary, we embrace that as being a jolly good starting point for any argument on statutory construction. And we say that absent a clear basis that the legislature intended something different from the conventional, that should also be the correct endpoint too. But our case here is also supported by linguistic and dictionary definitions, the case law in this jurisdiction. We submit it's supported by the case law from the European Patent Office as well. And we do say that my learned friend, by advancing his construction, seeks to cause the law to diverge from the European Patent Office on that point too. We say that is a problem for his case. The fourth and third appeal questions, and we both address them in that reversed order, these at their core concern questions of the correct approach to identifying the technical character of the invention and its application to the facts. So whilst it has got fact-specific aspects, it also engages points of wider general importance. And last, at the very end, I'm going to touch on mathematical method again. Sorry, the mathematical method exclusion, because my learned friend has sought to raise this in his written case. It's a very short point, and my learned friend doesn't dispute my summary of the law in my written case, which is well established anyway. Now, on that basis...
I can't see that that point is before us at the moment, the mathematical method, because the Court of Appeal may express sort of might view about it, but they didn't make any conclusion about it. There's not been any...
Well,
not been renewed here.
Sorry, yeah. Strictly, the hearing officer found in our favour on that. It's in paragraph 78 of the hearing officer's decision.
Right.
Sir Anthony Mann didn't deal with it because it was raised in post-hearing submissions and was too late. In the Court of Appeal, it was raised again and there were obiter comments made.
But my understanding is there wasn't opposition on your side to it being dealt with on its merits in the Court of Appeal.
Indeed, and we actually think it's better to have everything dealt with that it can be. And my only...
But it wasn't dealt with on its merits by the Court of Appeal.
Well,
they just said that they expressed a possible view, but they didn't express a conclusion on it. They didn't decide the point.
That's right. What we're concerned about, though, in this case very much is it going half-cocked and having another series of arguments when we get back to the Patent Office.
Right.
My position, just to be clear on that, is my learned friend hasn't disputed my statement of the law on this area, which, as I said, is well established. As long as he doesn't resolve from that or seek to introduce any arguments that are still unforeshadowed, we think it can be dealt with by this court, and it's an extremely short point, actually. So as long as it can be dealt with and subject to that, then we say it probably should be.
Could you assist me on this, Mr. Chaxfield? What happened in relation to the parallel application before the EPO pursued by your clients?
So my learned friend makes the point that we
happened?
We asked the EPO to put that one on ice. We saw what my lord had to say about the issue, and I don't think there's any criticism in that.
No, I'm sorry, but what happened before that? What was the outcome in the EPO thus far?
The outcome in the EPO thus far, and I'm not sure the claims are identical, I'd have to check that, but the outcome in the EPO thus far is the hearing officer has raised an objection under mathematical method, but hasn't, as I understand it, raised any objection under programme for a computer.
Thank you.
And in a sense, you'll come on to see in my submissions, that's actually how the EPO deals with AI, ANN cases, is they say if there is an objection, we obviously say there shouldn't be in this case and there, but if there is an objection, it's not a computer program objection. They don't view these as computers and computer programs. They say if there's an objection, it's under mathematical method, and that's what I'll address at the very end.
Thank you.
With that, I was going to turn to the substance, starting with a brief introduction to the technology. And just for orientation, my lords, we address this in our written case from 16 to 23. That's page 34 of the bundle. But an ANN is a structural machine which is made from nodes called neurons connected together by links. For each input to a particular neuron from the layer above, the neuron weights that input, so it might double it or halve it or add a bit, whatever. The neuron also has a bias which is applied to the aggregate of all the inputs, but in much the same way. And that neuron then serves as an input to each of the neurons it's connected to in the layer down. And it's key to note that it's this internal structure of an ANN which enables it to perform the function that it performs. So the function of an ANN is achieved through the input information cascading down through this networks of links and nodes and weights and biases, and different inputs to a node are given emphasized or de-emphasized by their weighting, and so it can collate or disaggregate certain collections of inputs or weigh them against each other or whatever, with the layers below doing the same, until eventually it all flows through to the outputs.
When you talk about the internal structure of an ANN, you're there excluding the weights and biases or including the weights?
Including the weights and biases.
Oh, okay.
So the structure of the links and the nodes have characteristics which are the weights and biases. And it's the combination of all four that results in the outcome.
Okay.
And indeed, as we'll come on to explain, we say it's actually artificial to try and divide between the things, the links and nodes, and their character, which is the weights and bias, their characteristic. It's like trying to distinguish a resistor from its resistance. And I'll come on to develop that.
Nothing new in any of that structure at all?
Nothing new in any of that. In terms of this structure, it's just, well, so I'm about to address, my lord, on hardware ANNs, and I think the point my lord is making is that in a hardware ANN, a physical ANN is nothing more than a box of electronics, as it was put in the judgment. It's resistors and wires, amplifiers. And so the links are nothing more than wires with resistors in them to give the appropriate resistance. And the weights are those resistors. The bias can just be an amplifier which raises or lowers the voltage.
I have a problem with your treating an ANN as a physical thing, given that you accept that it can be implemented either in its own form of hardware or in generic hardware, if you like. And as far as I can see from, which is a dangerous thing, attempting to do a bit of reading about it, it's normally described as a computational model, or it can be represented mathematically, can't it, an ANN?
Well, one can describe what at least in theory, one can describe what an ANN does mathematically. I say in theory because as soon as you have more than a few links and nodes, I suspect that...
Of course, you can't do the calculations yourself, but you can express the concept mathematically.
But the thing to bear in mind is that's also true of almost every invention in physics and engineering.
Right.
If you take a standard filter circuit, that can be described, and there's plenty of cases in the EPAI where that's just described mathematically. Mm. The way it's actually done is you have, in a filter, you typically have resistors and capacitors with particular values in a structure. You can say it's a filter circuit which operates so as to cut out everything below 202 gigahertz. You can describe it mathematically in more complicated terms than that, no doubt, but it is also just a structure which you can describe functionally. So the fact that something can be described mathematically doesn't make it a purely mathematical thing.
No.
Levers and cogs can be described mathematically equally, and they're just mechanical inventions.
Right.
But
equally, it's not purely a physical thing.
No,
it can be embodied in different physical objects.
So I was going to address a hardware ANN and then come on to a software ANN, because it is right that the implementations, there are two implementations and they are different. But the important point is that the ANN as an ANN itself, as a structure which achieves the function, is identical in each case. It's just how you choose to implement it. And as I said, that's an important distinction drawn in the European cases.
Okay.
But just going back to the hardware ANNs, the links may be nothing more than wires, and this is what the Court of Appeal said at 17. The weights may just be resistors. The biases are just an amplifier, which raise or lower the voltage. So in hardware implementation, an ANN is just a circuit, or a network as the name implies, of completely conventional electronic components.
which has been trained.
Sorry.
Well, the contribution is the training.
If I can say,
Because if you just have a circuit without training, it goes nowhere.
I'll come on, indeed. I slightly bulk the word contribution because it's freighted, but certainly the clever bit, if I could call it that, is what gives it its function is the training process. And I'll talk about that in a moment, if I may.
Just before we do, I think I started out with a rather stone-aged or Meccano-esque understanding of a hardware ANN, because if it's got a certain number of resistors in it, how on earth you trained a resistor? I mean, a resistor has a certain resistance stamped as a label on the outside of it, and how do you change it? But I think you're saying that all the resistors and amplifiers within a hardware ANN are themselves adjustable, so it can be trained.
During training, they will be, but once you've trained...
Once you bake it, it can't be, I accept.
Once you've trained... Obviously, during training, my lord's absolutely right, you have to have variability.
So you can train a hardware ANN?
Yes, you can train in hardware, and you can train ANNs in hardware and software, and Professor Pardo in his report says that's actually increasingly common given the complexity of ANNs of this day and age. So during training, obviously, you have to be able to change the weights and biases. Once you've done that, they're frozen and they stay the same.
Yeah.
And so if you want to make a copy of the ANN, you just print it out in normal components. So a hardware ANN is just a circuit with conventional components, and the information is processed just by the cascading of the electricity through that circuit, just as any basic circuit. Now, software emulations, to come on to those, we address those in paragraph 20 of our written case, just for orientation. But here a computer runs a software platform which emulates the ANN as if it were a hardware ANN. That's the language in the Court of Appeal, as if it were a hardware ANN. So it emulates exactly the same structure of nodes and links and weights and biases as in the hardware ANN. And as the Court of Appeal says, as ANNs at the level of the ANN, the software and hardware implementations are the same. They have the same architecture and function the same way to give the same outputs. And as Professor Pardo noted in his report, the question of how to implement it is just a question of which is more convenient or efficient in any particular scenario. And that's important for understanding what we say an ANN is, because as I said, under European law, the European law distinguishes the way an invention is identified at the level it's claimed, so what the invention claims, and the manner of implementation of that invention. So the former is the invention under the Act itself, the thing which is claimed, whereas the latter is merely an implementation choice which doesn't affect the fundamental nature of the claimed invention itself, and that's the Vicon case. Now that takes us to training, and an untrained ANN. In an untrained ANN, there's still a network of links and nodes and weights and biases, but when untrained, the structure and their values are effectively arbitrary or random. So if you put in inputs, it gives you effectively random outputs.
And do I understand, Mr. Chacksfield, you accept that ANNs in that form are entirely conventional and were at the priority date?
Untrained ANNs were known things at the priority date.
Yes, and what they could be used for. This the general processing. Not I understand you would say this particular application, but in general, the purpose of ANNs was known.
Yes, to analyse input information and provide useful outputs.
And it was known how to program them. Train them. I shouldn't have used the word program, I do apologise.
Indeed.
And how to train them was understood.
Yes.
At the priority date.
Yes, that's right.
Yeah.
Unless I'm poked from behind, that's right.
Yeah.
Now, the training process is an iterative process by which known data is tagged with what's called the ground truth, the desired outcome, and it's run through the ANN. And by observing the difference between the desired output and the observed output, you can calculate what's called the error, the difference. And then that error can be fed back up the chain to make tiny changes to shift the observed output towards the desired output. And these changes may be to the weights and biases of the links and nodes, but they also may be changes to the structure itself, since links and nodes may be removed during training by a process known as pruning. So a final ANN may have a different structure to the untrained ANN. And the result of this iterative training process is that the ANN obtains the necessarily internal structure in order to perform its desired function. Now,
one aspect is important, is this right, is how much training you do, as it were, because if you do too much,
you can overtrain.
It could deteriorate its effectiveness. Or
that's right. If you train too much, then the ANN becomes really, really good at identifying the training data, but it loses the ability to generalise. But I don't think that matters for the purpose of the case, but my Lord's reading is obviously correct too. Now, once trained, an ANN is frozen, so its topology and parameters become fixed and permanent. And at that point, it's entirely possible to make copies of that ANN. And we touched on this in response to some questions, but to do so, one has to ensure that the copy ANNs are exactly the same as the frozen ANN. So the same topology or structure with the same components with the same values. Everything has to be fixed and exactly the same as the original, or the copies will not produce the same analysis. The Court of Appeal discusses this in 13 to 15, and it's probably worth, if we may, turning this up. It's bundle tab 9, page 149. Page 149, my lord, sorry.
Which page are we on in the main pagination? The main bundle pagination?
It should be page 149 of the main pagination, paragraph 13, page 149.
Yes.
So in paragraph 13, Lord Justice Burr sets out that once trained, the network topology and parameters remain frozen, as I've just said. And then in 14, he sets out that since the network topology and parameters are frozen, that allows this specific pattern recognition machine, i.e. the trained ANN, to be taken forward and implemented. And he expands on that in 15, where he says that other ANNs of, to use his language, the same kind, and he explains in the second sentence, by that he means the same fixed topology of neurons, links, and layers as the trained ANN. But ANNs of that topology can be set up by transferring the weights and biases of the trained ANN into it.
Yeah.
So what he's saying here is you can have the same topology, so the same structure of components that come out of the training, and ensure those components are of the same value as came out of training as well. In other words, the same components. And you can see from the start of paragraph 16 that Lord Justice Burr here is discussing this at a conceptual or functional level. And what he's really getting at here is you can conceptualize a design task as taking the trained structure of components and then notionally populating those components within that structure with their known and desired characteristics. Now, in a sense, that involves a bit of mental gymnastics because it requires separating the components from their characteristics. But nonetheless, and as I said, a capacitor can't exist without a capacitance, but if one goes down that conceptual road, of course that's true for any circuit design process, indeed most engineering processes. You can conceptualize any circuit as designing the topology necessary and then populating the components of that topology with the specific characteristics that they're necessary. So the point here he makes is no distinction over any standard circuit. Now, my learned friend in the Court of Appeal referred to this point when seeking to find a program in an ANN, and I'll come on to that later, but for now it's worth noting 3 points. Firstly, Lord Justice Burr was careful and correct here to emphasize this only works if one takes the structure, the topology, of the final trained ANN. And that's for obvious reasons. The topology has to be the same, or the copy ANN will not in fact be a copy and it won't work in the same way. The second point follows from this, which is that I think my learned friend seeks to give the impression that one could use what he calls a naive ANN as a sort of general purpose device. So you could take a general purpose naive ANN with a general topology, and then take the weights and biases from any one of a number of trained ANNs to program, his word obviously, program the naive ANN to have the same function as that copy trained ANN. But that doesn't work because, as Lord Justice Burse was clear to point out, even on his conceptual approach, one has to start with the specific topology of a specific trained ANN, and then you have to use the weights and biases of that trained ANN. So when Lord Justice Burse is talking about a naive ANN here, he is talking about one specifically related to one specific trained and frozen ANN that you're wanting to make a copy of. But once one appreciates that, it's just, as I've said, making a copy of the circuit.
Well, Lord Justice Burse uses in paragraph 15 the concept of other ANNs of the same kind.
Yes.
And then he explains what he means by that. And then he goes on to use the expression naive ANN, machine A. And by naive, he there means an ANN of the same kind, doesn't he?
Yeah, indeed, indeed.
Yes.
And that's important because if you don't have the same structure of links and biases, then you can't, well, in fact, you can't, if you have a different structure, you can't even transfer, it just doesn't work. You can only use, this is why he was being very clear here to use those words of the same kind and then to expand on what he meant by that, because he very much has in mind the point that you can only start from the structure of the specific pattern recognition machine, the trained ANN you're talking about.
I'm not sure he's not taking it in two stages. He talks about, by the same kind, he says he means the same fixed topology of neurons, links, and layers. He's not there talking about weights and biases, is he?
Correct.
So he's saying an ANN which is the same kind, of the same kind, has got the same number of layers and the same number of neurons and the same connections between them, but it's naive as to what weights and biases it's going to have inputted into it.
Yes, so he's saying it's the same structure as the trained ANN.
Yes.
Because this is following from his discussion in 13 and 14. You've got to bear that in mind. In 13, you've got you're freezing your network topology and parameters. In 14, he then talks about once the network of topology and parameters are frozen, this allows the implementation. And in 15, he expands on that. So it's the implementation of this pattern recognition machine, the end of 14. And then in 15, he expands on that briefly, as he says. And when he expands on it, he's very clear when he's discussing that it has to be the same fixed topology. He specifically uses the word fixed topology.
Yes.
And that's a reference back to the fixed topology of the trained ANN that one is considering. And the reason he says that is because different trained ANNs, even if you started with the same starting point, they will have different topologies because the structure can change during training as well.
Well, sisters, if you're drawing this particular distinction, how would you, on this approach, start with a naive ANN, but with the topology of the trained ANN?
So the naive ANN has to have the same structure of neurons, links, and layers.
And how would you achieve that is my question.
We just...
But the submission you've made to us, as I understand it, is that the training process can alter the topology.
Yes.
So my question to you is, if you're going to transfer the relevant information from one ANN which has been trained to another which has not, how do you ensure that the untrained ANN has the relevant topology of the trained ANN?
So once one has a trained ANN, I think, sorry, this may be the question my Lord was asking, you can print out a great big list of its links and nodes and weights and biases and its structure. So you just print it out.
One of your points is, I think, that there's no conceptual difference, if you like, between the topology, as Lord Justice Burse is describing it, and the weights and biases. They're all part of the trained product, if you like, which you replicate when you produce them, other versions of it. Is that right?
Exactly.
Is that right?
So all that's being done here is splitting up the simple statement of you can copy the ANN into two parts. It's just a two-step process for saying you can copy the trained ANN. And that's of course you can. And that's how they're made in a hardware version. That's how they're made in practice. You just print them out by their thousands or millions. But yes, it's just a two-step process, conceptualization of what is really just design. And indeed, that's the the last point I was going to make on this, because my learned friend in the Court of Appeal seeks to draw from this analysis a suggestion that one can call the weights and biases in this process instructions, and that's how they go on to there's a program for a computer. But if one thinks about it, exactly when my Lord Legate was just really postulating, if you try to call them instructions, they're instructions to the designer, not instructions to the ANN. They tell, even if one takes my Lord Justice Burse's conceptual approach, they're just saying, copy the structure, and then I'm instructing you to set the values of all the components to this particular value. And that's just describing design or manufacture. And so this argument does not, in my submission, support my learned friend's suggestion that the instructions are to be equated to a computer program. They're not instructions for the ANN to perform a particular function, which is what a computer program does. It tells the computer to execute certain functions. They merely define the nature of the components of the ANN itself, and those components then just behave in accordance with their own nature and the laws of physics.
If I may respectfully say so, you're elaborating to quite a substantial extent on the words that the judge has used here. Do we find what you've explained to us in Professor Pardo's report at paragraph 41?
He says something he basically says that in paragraph 41. The language is slightly different, but the basic thrust of the message is basically the same.
Right, thank you.
Yep.
Do you agree with the intervener's characterisation of it, which is, I think, essentially that the weights and biases are data?
I find that description a little bit difficult, I'm afraid, and maybe that's because I'm a biologist and everybody else here is a computer scientist. But I think I do agree with them. I just think I find the language difficult, because I think what they're getting at is exactly the same point I'm getting at, which is the weights and biases just describe the nature of the components, which then just act according to their nature.
Perhaps another way of putting it might be to say that it is information which is part of the information that's used in the process, for the process which generates an output, rather than part of the process itself? Or is that not a good way to look at it?
It's a feature of the links and the nodes. The weights and biases are features of the links and nodes.
Yeah.
And the links and nodes then just operate on data as it cascades through. What they aren't, so if you'll have seen in our written case, that we put in a whole bunch of definitions and some argument about the nature of an instruction in the computing context. And the essence of those is an instruction in a computer program or a computing context is a command from one thing that tells something else what to do or what function function in the technical computing sense to execute. The weights and biases aren't anything like that. They are just descriptors of the components. And so if one thinks about it in the hardware implementation, because it's sometimes easier to do that, it's just the resistance of the resistor or the gain of an amplifier. And that's why we say that insofar as they're instructions at all, they are instructions for the designer or the manufacturer. They're not instructions within the ANN to execute a function in that computing sense.
How does that apply to a software ANN?
Well, it's the same, because a software ANN emulates. So an emulation, it's a bit like a simulation is where you approximate a real thing in a model, and an emulation is where you try to recreate as accurately as you can thing.
So a software ANN will have a virtual amplifier and a virtual resistor.
It'll have links.
Virtual in the sense that it's not a real one, but it does the same thing in terms of getting from A to B.
Yes. So a link will have a weighting, and that is functionally the same as having its resistor or the amp, and the biases will have a bias, and that's functionally the same as the amplifier. Yes.
Thank you.
So, subject to any further questions, my lords, I was going to turn to the application itself.
So I think you're saying that sticking with the hardware ANN, once it's trained and has been frozen, or is simply a simple copy of one that's already been trained and frozen, then it doesn't really take instructions from anything or anyone. It just works in accordance with its characteristics.
It's just a circuit. And that's why we say it's the same. You'll have seen we say at a qualitative level, it's exactly the same as a digital filter circuit, the circuit you find in a smoke detector, any of them. They're just circuits which operate in accordance with the nature of their components. So we do exactly say that, my lord.
And you say we can get that all from Pardo at paragraph 41.
So, well, Professor Pardo talks about this much more. The point that Professor Pardo says in 41 is dealing with the fact that once the topology and the parameters have been frozen, you can then make copies of them.
Yes.
And so there are other parts of Professor Pardo's report. So in 41 he deals with those bits, but he does deal more broadly with the nature of ANNs and their construction.
Can you unfreeze a frozen ANN?
Well,
I suppose that depends how you freeze it.
the ANN, an ANN that's actually been trained and so must have that kind of variability within it.
Yeah.
Imagine you can unfreeze it. If you then just print it out and then with normal components, which will have a fixed value, then you'll just got a circuit.
Then it's not trainable. Yeah.
Now, in terms of the application, I'll take this swiftly as I may. We start in 25 of our written case, and as we explain there, the invention relates to a system, or the claim for a method of use of that system. And the system comprises the ANN of the invention. That's what we call the physical properties ANN, as well as other components such as a database, a communications network, and a remote user device, so a computer or a tablet or a mobile phone. The invention as a whole provides improved media file recommendations. And as we note in paragraph 25, the exemplary focus of the application is music, but it encompasses static images, moving images, text, and applications such as medical reports. Now, in 26 to 29, we describe the training process in a degree of detail. But the key points are really this. What one does is take a library of training data files, and you tag each of those media files with a written description of that file or the music. And it's because these are written descriptions that the application refers to semantic properties. Now, as we set out 27,
Who tags it?
Sorry?
Who tags it?
So
Is it another ANN using linguistic interpretation, or is it a programmer?
The tagging will be by people. Whether you scrape descriptions off the internet or you have roomfuls of people, I don't think it addresses and I don't think it matters. But it's a written paragraph about each piece of music.
Whether people produce anything like consistent descriptions of the same piece of music, I've no idea. I mean, it doesn't really matter, I don't suppose, whether it's any good or not, but the whole concept seems quite
well, I think
speculative.
If one has not insufficient data, you may have problems, but as long as one has a sensible approach to data. Now, so once you've tagged that data, first of all, the written description is analysed by a natural language processing, or NLP ANN, which analyses the written description of each track to produce what's called a semantic vector, a string of numbers, in the so-called semantic embedding space. Second, there's a physical properties ANN, which analyses the physical properties relating to each track to create a vector in the physical properties embedding space. Now, this is a purely physical analysis based on, for example, properties representing tonality, rhythm, timbre, things like that. Now, during training, the separation distance between the two semantic vectors in the semantic embedding space is calculated for each pair of tracks. Then the separation distance between the physical property vectors in the physical property space for each pair is calculated. And then as we set out in R29, what happens is the physical properties ANN is then tweaked so that separation distance between the two physical property vectors matches a little better this corresponding separation distance for those two tracks in the semantic embedding space. So the result is that the physical properties ANN is trained so as to embed close together in the physical properties space tracks which in fact are semantically similar, and vice versa. And it's this physical properties ANN which is the only one used in the system once trained. Now, once trained, the system can therefore receive unknown media files, and the physical properties, but only the physical properties, of which are analysed by the physical properties ANN to produce a vector in the physical properties embedding space. The system can then identify other tracks in the database in that system, which have similar physical property vectors. And those identified tracks will, in fact, also have similar semantic properties. Now, the hearing officer held, and I'm going to show you this shortly, that the recommendations produced are therefore better than the prior art, but that improvement is only a benefit of the invention. It's not how the invention works. Now, the recommendation message and track can then be sent over the communication network to the remote user device. But as your lordships will appreciate, the physical properties ANN is not expressing objective views on the tracks. It doesn't have aesthetic opinions. It doesn't have musical tastes. All it does is analyze the physical properties of the received track and compare that to an analysis of physical properties of other tracks.
What it's done is this, isn't it? It's learned through the training process what no humans know, namely precisely what physical differences between different tracks produce the semantic difference on the vector.
It's learned to equate, it's learned how to equate the complexities of the physical properties of music with the semantic descriptions. I think what my lord said is correct, yes.
Okay.
But its analysis is always just physical. The fact it aligns with the semantic properties is the benefit.
Its analysis is just physical, but
Yes,
by being trained to converge its physical analysis with the semantic analysis, it's effectively learnt what are the unseen physical differences which, if you like, generate the semantic difference.
Yes, I think that's right. It doesn't mean that the physical embedding space and the semantic embedding space become the same.
No.
Your vectors may be, well, they may be in different dimensions and all sorts, but different numbers of dimensions.
Oh, yeah.
But yes.
They just correlate better.
They correlate better. So once if you take a physical property vector and you look at another track with an adjacent physical property vector, you'll know that they're, in fact, semantically going to be similar. Yep.
Yeah.
Now, there's some debate in the written cases about the contribution of the invention. But the hearing officer accepted my summary of the contribution invention, which he set out in 53 of his decision. Can I take my law set? It's in the bundle. It's tab 12 of the bundle at page 209. And if my lords could just read that, please.
Which paragraph?
53, and then the summary underneath. And there are, in fact, no less than 8 points I want to draw out of that. First, the invention is to an ANN-based system. That's the very first sentence. The invention encompasses the physical properties of ANN, but it's part of a wider system with other components. Secondly, still in the first sentence, the system is a system for providing improved file recommendations. That's a summary of what the invention does. Third, you see that it may be hardware or software implemented, and we discussed that in the context of the ANNs. And fourth...
Sorry, third is what, sorry?
Sorry, you see from the second sentence, invention may be hardware or software implemented, but which reflects the discussion about the implementation of ANNs. And then fourth, you see there is a discussion of the ANN and its training, and we've been through that. But
It says the fundamental insight is the training.
So
that is the fundamental insight.
That's the clever bit.
Well, it may be the only contribution.
It depends on the word contribution. The word contribution is quite a freighted word, but certainly it's the fundamental insight, it's the manner of production of the ANN. That's a bit that's clever. But fifthly, if my lords could look at the final sentence, you see that it says once starting, you'll see the other components of the system referred to. So a database, a user device, a communications network. Those are all explicitly being part of the contribution.
But I think you would accept they are entirely conventional.
They are conventional.
As is the ANN hardware.
ANNs themselves are no,
Yes.
sure.
Yeah.
We, of course, say none of that matters, and I'll come and show you the law, but,
Yes.
but as facts, those are true.
Yeah.
Sixth, you'll see the system involves an interaction with and analyzes an external media file. So it interacts with the real world at that front end. And seventh, a recommendation message and file are sent out over the communication.
Just pausing there, it can only interact because of its training.
Yes, only useful interact because it's training.
Yeah.
And seventh, a recommendation message and file are sent over the communications to a remote user device. So that is an interaction with the outside world at the back end of the invention. And lastly, you'll see that in the same sentence, it said that the invention operates swiftly and accurately, which the hearing officer expands under paragraph 54. He says the reference actually captures that the system is better at identifying and recommending files.
But you're not suggesting it's a better computer.
Well, I will come on to that because I do say that's not my primary case at all. But I do say that if the Court of Appeals approach, and my learned friends approach, were to be accepted, then in fact this does become a better computer case because what one has is a poorly defined computer, an untrained ANN, that's made into an efficient and faster computer. And we say that's exactly what the better computer cases are about. So it is a third-tier argument as a consequence of the Court of Appeals construction that I do say that.
Well, then every single computer program would result in a better computer.
No, the difference is because of the nature of an ANN, of an ANN and its training, and I'll come on to that, my lord. It's because the computer program, as it were, itself, if you take my learned friend's approach to what program means, changes the structure of the computer itself. And that is a classical better computer case. And it's worth bearing in mind the better computer cases involve software resulting in a better computer. So software that improves the way that databases within the computer talk to each other, things like that. Better computer cases involve the interaction of software with the underlying hardware. Also, just for my lord's notes, in 48 and 49, which is on the previous page, the hearing officer records his conclusions that the recommendations are better and the system is simpler and faster than the prior art again. And he does so. When he does so, he says that that was based on what he says much discussion about the benefits over a piece of prior art known as Apple, which was the only piece of prior art, which was set out in our skeleton, Professor Pardo's report, and orally before the hearing officer. And he accepted this. And the reason I mention this is because the hearing officer's conclusions were based on substantive argument, so substantial argument, but in this court, my learned friend seeks to go behind that, and we say it's too late for that. So that is the contribution. But in my learned friend's written case, he does appear to seek to go behind that. And if I can start with his paragraph 104, so that's tab 6, page 113. It's tab 6, page 113.
113.
113.
Thank you.
If the tab numbers are of no use, I'll just give the page numbers.
And tabs don't help us. Well, they don't help me. I don't think they help anyone.
No. They can, but not really.
Okay.
You can have them on the... We can display them.
So, in paragraph 104, he says, known common or garden features such as conventional database networks as it can form no farm the properly determined contribution. Now, I contest that as a matter of law, but we'll come on to that. But he then goes to say, such features, whilst present in the claim, were excluded from the agreed contribution by the appellant before the hearing officer and maintained throughout. Now, I find that something mystifying and wrong. I've shown, my lords, the contribution which I advanced and the hearing officer accepted, and that was to a system explicitly referring to the database, communications network, and the user device. So they explicitly are part of the contribution. And then at my learned friend's paragraph 110, in that paragraph, he disputes, he seeks to undermine the contribution, and he disputes the benefits of the invention, that it's swifter and better and faster. But that's not open to him at all either. As I've shown, my lords, those were accepted by the hearing officer, who indeed heard extended argument on that matter. So I do flag that we don't accept any of that, and we say it's not even open to my learned friend to put it forwards. Now, with that, I was going to turn to the law in the EPO, subject to any further questions from my lords.
I mean, it may be that the answer is simply to, for present purposes and avoiding semantic difficulties, that the hearing officer is quite clear in referring to the key insight, or I think elsewhere it was called the clever bit, but that is in the particular pairwise comparisons of the training files. I don't think you dispute that. It is then implemented in the way the hearing officer goes on to elaborate.
I accept that's the key insight, yes, indeed. But it is, when one is summarising the invention has many more components to that. Yes. So I'm going to come on to show, my lords, that's really important.
And we find all that in Claim 1.
Indeed. It's a summary of Claim 1, in effect.
Yes.
But yes, but the point is, the fact that the database is old, or the input file is a conventional input file, simply doesn't matter. I'm going to come on to show you that.
Well, it may not matter for all purposes, but it does certainly matter for some purposes.
Can we see where we get on my lord's question? Yes. I'm not sure it matters. It's a part of the analysis, but I'll come and show you that. But this is where Aerotel goes wrong and the EPO does it differently. And it's important to bear in mind, I'm talking about the law of the EPO here. Yeah. Aerotel says take those bits out. The EPO asked a much more sophisticated question, which is to say, which features of the claim interact with other features of the claim so as to produce the invention as a whole? So if the invention as a whole is a better system for providing media file recommendations, and the clever bit interacts with other bits, even if they're conventional other bits, they are all to be taken into account when considering the exclusions. And I'm going to come on to a case called Vicom, which is the classic case on this. That was a case where it was a computer-implemented method. It was a mathematical method.
Just to orientate myself, using the any hardware approach, you then got to combine it with convic. And so therefore, the invention as a whole, you concentrate on the, you don't just concentrate on the clever bits, you concentrate on whether it's got any hardware application. But then you take it all out again when you come to the inventive step.
No, my lord, one doesn't, and that's really important as well. For inventive step under convic, that is exactly where one has to look at the interactions between all the features to define the invention as a whole. I'm going to show you this, and this is why I'm going to spend some deep time on the law. And so in Vicom, you had a conventional computer. There was an analysis of a conventional digital media file, an image file. The only clever bit or insight was in the mathematical algorithm implemented using the computer program. Under an analysis of Aerotel, you strip out the file, you strip out the computer, all you're left with the program, and it fails. The Europeans say, no, that is an invention properly characterized, which is a better method of analyzing a file. And when you then go on to look at the interactions, the computer program, or the algorithm in the computer program, it interacts with the external file because it performs an analysis on it. And so one takes into account all those features when considering exclusions and under inventive step.
We have to be a little bit careful about that because certainly I would need some persuading that it was not a part of conventional English law to take into account interactions in deciding whether or not there is an overall contribution or technical advance which justifies a patent. So you may have old features, but if they interact with new features in such a way as to produce a new effect, then under entirely conventional UK analyses, that would be taken into account. Would it not?
Well, I'm not sure that's right, because step 2 of Aerotel involves subtracting out old features, and step 3 requires you to look at the contribution. So if one just follows Aerotel like that, I would agree, my lord, that there are cases which would perhaps taken a slightly more nuanced approach to things, but Aerotel itself says remove the features, the old features, and then 3 ask if there's a technical contribution. So if your interaction is between in the clever computer program, and an old thing such as the external digital media file in Vicom, that gets stripped out at step 2.
Well,
I'll show you that one. Sorry.
you carry on. It's...
Now, my basics, as I said, I have an overarching submission about the European law, which is, and you'll have seen the cases we refer to in my written case, of highest authority repeatedly state that this court should align the law here with the European Patent Office, unless there's a jolly good reason not to do so.
Well, including Aerotel itself.
Including Aerotel itself, indeed, and Symbian. And there's Lord Justice Jacobs' pithy comment about we should follow the Commodore unless the Commodore
Why is it a Commodore? I always thought it was an Admiral. Is it?
Yeah. My Lord, I don't think I'm going to engage with you on that one. I know when I'm beaten.
Well, I'm assuming he's referring to Cloudsley's shovel, but I'm sure he was an Admiral.
I agree. I had the same thought myself, my Lord. The European law is set out in our written case, starting at 94. That's where we summarise it.
Is that a paragraph or a page?
Sorry, paragraph 94 on page 54 of the bundle. And I propose to take much of this briefly, but to spend time on 2 particular points, namely the correct identification of the invention, or its technical character, under Vicom and G19. And that's important to understand the law generally and also appeal questions 3 and 4 as well. And second, to identify how the identification of the invention plugs into the question of inventive step, because my learned friend seeks to suggest, I would say wrongly, I'm trying to trick the system here, so I need to address that too. Now, the way the European Patent Office thinks about the law is based firmly in the structure of the statute itself. And if I can start with that it's tab 69, page 1454.
Did you say 464?
Sorry, 14, I did, 1454, I apologise, I misspoke. 1454. So here one sees that for the grant of a patent, there must be an invention, and that invention must be new, involve inventive step, and being capable of industrial application. Now, the way those 4 separate components interact is fundamental to the European Patent Office's analysis. They describe this as a two-hurdle test. First, one needs to identify the invention. And then second, one has to determine whether that invention is patentable, having regard to novelty, inventive step, and industrial application. And just for your notes, that's the Hitachi case and the Duns case set out in 61 and 63 of our written case. But a key point that comes out of this is that questions of whether the invention is new or involves inventive step or is different from what was known at all does not matter in the European Patent Office's analysis when identifying the invention under the first hurdle. Those questions are only relevant to the consideration of whether that invention is new and involves inventive step. Now, the structure of the English Act is very similar, and that's found on page 1460. And it takes essentially the same form. Section 1.1 defines an invention and then a patentable invention, spelling out the distinction we just saw. But I should point out there's Section 1D slightly confuses matters since it refers to the exclusions there, but nobody suggests anything turns on that. And the other thing I should mention is Section 125 of the Act, which actually I mentioned earlier, which states that the invention is, unless the context otherwise demands, that set out in the claims. And nobody suggests the context does otherwise demand here. So the invention is the thing or method as defined in the claims, subject to the effect of any excluded subject matter as such. Now, from this one, I can now deal with the EPO's any hardware approach. This arises very simply out of that structure. And
whether something's an invention is a prior question, is the point, is it, to whether it's new, involves an inventive step, or is capable of industrial application?
Yeah, it doesn't matter whether your invention is new or old at all, that arises later. So if you have any bit of hardware, a computer or a database, that is inherently something that's not under the exclusions. You have an invention, and then you have to decide whether the invention, taking the claim as a whole, is a patentable one.
And you say that flows ineluctably from the first 3 lines of 52.2.
Yes.
Yes.
Indeed. And that is absolutely the European analysis. Now,
May be regarded as is also deemed not to be.
Yes.
And whether otherwise objectively they look like inventions, if they fall within the exclusion, they're deemed not to be inventions.
yes, or insofar as they features of the claim fall within the exclusions, then you have to ignore it for the purpose of identifying the invention. And you get that from 3, which says only included to the extent they're claimed as such. Yeah. Now, the other point, which, if I may, to draw out of 52.1, is the mandatory language. Inventions shall be granted for any inventions in all fields of technologies. And as we've seen from our written case, that was incorporated into EPC 2000 to align the language with TRIPS Article 27, but it was declaratory of the previous law anyway, and we referred to a case called IBM, which set that out. Now, the exclusions then under 52.2 and 52.3, as my Lord Briggs just said, the way the statute operates is that these bar the excluded subject matter from forming part of the invention at all, subject to the important as such limitation in subparagraph 3. And as we set out in our written case at, just for your notes, 40, there's a potential tension between these 2 requirements, lest the application of the exclusions results in excluding matter inconsistent with 52.1 and Article 27 of TRIPS. And the way the EPO threads that need is as follows. Its basic precept is to give paramountcy to the requirements under TRIPS Article 52, TRIPS in Article 52.1. And so the EPO says that any invention in any field of technology, or as they often call it, a technical invention, cannot be excluded. And we set that out under 42 and 43. Accordingly, the EPO considers the as such limitation serves to limit the exclusions under 52.2 to be narrow and to apply only to abstract and intellectual creations, which are not technical or in a field of technology. And this is why the EPO uses this language of technical features. It uses this to mean things which are inside and outside of the excluded subject matter. And it uses those to indicate that no feature which is in no invention or feature invention which is in a field of technology can be excluded. Now you see this basic definition in the G119 case. If I can show my notes that, it's tab 55, page 1215, paragraph 32. And my lords will see that, as they set out there, non-technical features refer to features which on their own would be considered non-inventions under 52.2, in other words, would fall within the excluded subject matter. Later on, I'm going to come to the distinction between a technical feature and one which contributes technically, which is another linguistic and important distinction.
Do we need to understand fairly precisely the context being referred to at the beginning of paragraph 32?
So the context is, on the previous name of the page, it's the convict approach to the step. And I will come on to convict shortly, my lord. So yes, so the point the EPO make is that when you're considering obviousness or lack of novelty applying convict, what one needs to do is identify all the features, and I use the word deliberately, which are relevant to the invention, excluding all those which should be excluded. And in fact, the test, as we'll see in a moment, is you include all features which contribute to the invention, and you exclude all features which do not contribute to the invention. And the reason that language is important is because the EPO is very clear that a feature can be non-technical in the sense of on its own, in isolation, fall within excluded subject matter, but it can then interact with other features so as to contribute to the overall invention. Now, the consequence of this is that even when a claim relates to, or so uses or is implemented using, a program for a computer, if that claim concerns an invention which is in a field of technology or technical, then it cannot be excluded from patentability, and the exclusions do not apply. And that's set out in DUNS, which we refer to in our paragraph 46. And that's how the EPO threads this needle between the exclusions, which are therefore very narrow, and the requirement to grant patents for any inventions in all fields of technology. That in turn raises the question of what a field of technology is and means. And we address this in our in paragraph 47 of our written case. And my lords could just read what we say there, actually.
Page.
Apologies, my lord, that is on page
42.
Thank you.
47, did you say?
47 on page
Yeah, page
42.
42, yeah.
So whilst the EPO has stated that the term technology cannot be categorically defined, not least to allow for further developments, we submit that its essence is the practical application of scientific or engineering knowledge. And I note my learned friend doesn't dispute this in his written case. And we therefore pull this all together and summarise where we get to in paragraphs 48 and 49 of our written case. And if I can invite my lords to just read that, unless you have any further questions on it. Now, there's a final point to note in all of this, which is that, in a sense, the any hardware analysis is a bit of a shortcut. Because what the any hardware analysis does is it identifies that there is an invention, but it doesn't identify the totality of that invention. And so we address this in paragraph 67 of our written case on page 47 of the bundles. And what we point out there is that before one moves on to questions of inventive step and convict, one has to identify the invention in the Article 52 sense as a whole, including all matter to be included and excluding all features to be excluded. And if I can show my lords that in G119 itself, it's bundle tab 55, it's page 1217. 1217.
1217.
1217. That's that reference. 1217, paragraph 39. Starts the two-hurdle approach of computing inventions. Action entails 3 steps.
Well, the two-hurdle approach is described in 37.
Yes, so the first hurdle is identify the invention. The second hurdle is patentability, having regard to novelty, obviousness, and industrial application. So the point here is that though the presence of an invention demonstrates at least an invention, sorry, I've already said this, in order to properly assess patentability, one has to identify the totality of the claim features which contribute to the invention and those which do not. And I'm going to come on to explain in a moment how one assesses that, but I want first to look at how this feeds into the analysis of inventive step itself. Now, the analysis is actually very simple.
Do they use the words any hardware in G1?
They do. I think it's, remember, I think it's 24 and 25. But if my learned junior can find that, I'm sure. So it's 28, 29. It's cited at the bottom of paragraph 66 and 47 of our manual. It's bundled on page 1212.
Thank you.
And there's no doubt, there's no suggestion that it's wrong to say that other than the EPO applies, it's absolutely applies the any hardware approach. It's described in Dunn's itself as being established case law as well. So, sorry, going on to inventive step, if that's convenient, the analysis is really very simple. As we've seen, Article 52.1 demands that the invention be identified, having regard to that which is claimed, and having regard to the excluded subject matter as such. And then that invention is then to be tested for patentability. Those are the hurdles. What matters for the purpose of inventive step is that the Article 52 invention, but only that invention, is tested for patentability. So you don't include things which are excluded subject matter, but you don't treat the patentee unfairly either. Now, we set this out in our case, in our paragraph 68, by reference to the bullet points in Dunn's. And if I could, that's on page 47 of the bundle, if I can invite my lords to read through that, please. It's paragraph 68, page 47. And you'll see the first two bullets are thus statements of the law.
I'm so sorry, which paragraph you want?
Sorry, 68, and under paragraph 68 on page 47, you have 3 bullet points.
Oh, I'm sorry, yes.
Those are bullet points taken from Dunn's, but also cited verbatim by the enlarged board in G119.
Yeah.
And the first 2 bullet points are statements of the law, and that simply is the logical consequence of the structure of Article 52.1. And you'll see here, the language we'll come on to, that what matters are features which contribute to the technical character of the invention, and you exclude non-technical features, and we've seen that a non-technical feature is a feature which is on its face within the excluded classes of subject matter. You exclude those insofar as they do not contribute to the invention. And then the third bullet point describes the application of that law in the context of the EPO's problem solutions approach. Now, one can see essentially the same analysis, but quite usefully expressed, in the head note to the convict case, but that's in fact cited by the enlarged board in G119 at 31, so that's page 1214 of the bundle. Cites a head note there, and I should mention that head notes in the EPO are drafted by the deciding board itself. They're not sort of external editorial things as they often are in this jurisdiction. And here it's cited by the enlarged board.
So you like us to look at convict now? Or,
It's the head note, but it's cited at paragraph 31 of G119.
Yes, okay.
Page 1214.
Yeah.
Thank you. Thank you.
So the first paragraph of the headnote is the general statement of the legal principle, and as I said, that simply follows from the structure of Article 52. And the second paragraph is the application of that principle in the context of the EPO's problem-solution approach. But it's the general statement of the law which really matters. And so long as the invention is correctly identified in the first stage, it doesn't matter whether in the second stage of the process, inventive step is assessed by Pozzoli, or the problem-solution approach, or any other approach. My lords may recall from the written cases, in both these jurisdictions, problem-solution and Pozzoli, they're commonly applied, but they're always described as optional, and what matters is the statute. And what matters, therefore, is you correctly identify the invention, and then you ask, is it obvious, applying whatever particular approach one wishes to ask. And we set this out in our written case at 134, at bundle, at the page 64 of the bundle. If my lords could turn that up, 64. Now, this is important.
So before doing that, it would be helpful for me just to see how you apply paragraph 31 and the first part of the headnote of Convic to the facts of this case. To the facts of this case.
I will. Well, I can come on to do that. We don't have any prior art because obviousness is reserved to the Patent Office. So below, we haven't had discussions about obviousness, but I can explain how it applies over just any sort of any conventional A&N, rather than a specific bit of prior art. I can come on to do that. I can think about that over lunch one. Sorry, we start the discussion of obviously 134, but it's really
I just don't, sorry, coming back to it, but I failed to understand why it is that you just can't, as a matter of theory, hypothetically, apply Convic to the facts of this case.
Well, I can, my lord, quite simply, but
yes.
The step that we need to come to is how one identifies features which contribute to the invention as a whole,
Yes.
which is VICOM and G119, and I'm about to come on to that. What those two cases emphasise is that the VICOM emphasises you've got to identify the invention at the right level of generality. So there, although it was a computer that implemented a mathematical algorithm to analyse an external data file, the invention is described, and from my head I think it's paragraph 4, as being a method of better analysing a digital data file, an image file. And what one has to do is you then have to ask which features contribute to that invention. In that case, the clever mathematical algorithm contributes to the method. And what VICOM is really careful to distinguish, and we'll see this, is between the steps in the claimed method or the features of the claimed apparatus and the computer program that tells the computer how to perform those steps. And you can claim what the computer does. What you can't claim are the instructions that tell the computer how to do it, implement it. And that's why it distinguishes between the invention as claimed and the manner of its implementation using a computer program. So in VICOM, properly analysed, what the invention is this better method of analysing a digital file. That interacts with the digital file, which is an external physical entity, as a language they use in VICOM. You therefore say, is that obvious? Is it obvious to interact with the physical entity in that way? Is it obvious is that invention as a whole obvious? The answer is no. Well, unless there's any prior art, but the answer is no. In our case, it's similar. If we're right about an ANN not being a computer program, it kind of falls away. But if we're wrong about that, you ask yourself, well, we've got an interaction with an external digital media file. We interact and analyse that with our ANN. And let's assume it is a computer and a computer program for the purpose of this discussion. That is an interaction. The consequence is also an interaction with the database, and the consequence is another external interaction, the production of a digital file. The invention, as you saw in the contribution, overall is a better method of making media file recommendations. Vicom, as we'll see, will say the fact you may use a computer and a program to implement it simply doesn't matter. You ask yourself whether that invention overall, with the steps involved, is obvious, and the answer is, at least on a standard A&N, there may be specific prior art, on a standard A&N, not at all. So the fact that the inventive insight may be focused on the A&N itself, just as in Vicom, doesn't matter as long as you have an external world interaction. And that's why Vicom is all about correctly identifying the invention at the right level of generality. And what G119 does is it provides a structured approach to identifying all the features which are relevant to that invention and excluding all those that aren't. And it does that by this interaction analysis and identifying features which contribute to the invention. So, my Lord, does that address? So in 136 of our case, we address how one feeds in the analysis of Article 52.1 into the obviousness analysis. And as we particularly, it's an important paragraph, the particularly important point is the second sentence.
You keep calling it the obviousness analysis. I'm assuming you're just using an English anagram for inventive steps.
Sorry, yes. My note gets it right, and I get
just
it
so long as I'm,
yes.
just so long as I've understood that correctly.
My Lord is absolutely right, and you'll have to forgive me for that. Indeed, one could say novelty and inventive step, but generally it's inventive step that matters. The point we make in 136, once one understands the structure of the Act, is that the key thing for correctly applying the EPO's analysis to Pozzoli is just to make sure that for a mixed claim, a claim with some features that are non-technical, the claim is properly construed to identify features which contribute technically to the invention as a whole and to exclude ones which do not. And my learned friend actually says the test is basically the same. He says that in paragraph 53 of his written case. That's on page 96 of the bundle, where he says that the modified convict approach involves excluding from the assessment of the claimed invention all features that do not contribute to the technical character of the invention, features that fall within one or more descriptions are not considered unless they contribute to the technical problem, technical character of the invention. Now, as such, going back to our 136 and 137, as we say there doesn't appear to be any debate as to what the law requires. It's just the point we are making in these paragraphs is that they're actually easily folded into properly identifying the invention under current Pozzoli Step 2. One could, if one wanted to, one could write in a Step 2A. And if I can read one, I've actually got this written down if it assists. But one could write in a step that says, when considering a mixed invention, the assessment of inventor step must take into account all those features that contribute to the technical character of the invention and exclude those features which do not contribute to the technical character of the invention. Whether non-technical features contribute to the technical character of the invention has to be assessed in the context of the invention as a whole. And that's basically to take the text from Headnote 1 in paragraph 31 of G119, together with the clarification in paragraph 32 of G119 about assessing what contributes to an invention.
But where is the distance between you in relation to the second sentence of paragraph 53 of the Respondent's written case? I thought I was endeavouring to put that point to you a little bit earlier, and I understood you not to accept it. But the respondents themselves say, do they not, or accept that exclusions are only considered for the assessment if they contribute to the solving of a technical problem?
I apologise if I misspoke earlier. The point I'm making is I think we're both saying the law is, in terms of the assessment of the invention for the purpose of assessing inventive step, is the same thing. You have to identify all those features that contribute and exclude all those non-technical features which do not contribute.
Thank you. There's a bit of abbreviation in the bit in brackets at the end of 53, isn't there? I mean, unless they form part of the solution to the problem. One assumes that some of the features in your invention are not features in the prior art. And the problem is that then the problem with the prior art is it's not there.
Yes, my lord, I hadn't really focused on the parenthesis at the end.
No, okay, but I'm just trying to make sure I've understood fully what's being said here. I mean, no doubt I can be put right in due course by the author, but we're looking, aren't we, at features within the invention which would be excluded unless they contribute to the solution of a technical problem.
My lord, that's right. I don't know if it would help. I actually printed out just this morning some copies of what I just read out. I don't know if that would assist, just so you've got it in front of you. If not, it's fine.
I hope I
Could he email it to us?
Nice to have it by email, please. We
I can arrange for
we
that.
don't use much by web paper these days.
So, in our paragraph 136, we basically thought it was unnecessary explicitly to write it out, because all I've written out is properly identify the invention. But of course, my lords would think it was useful to add a step 2A in this kind of case. Well, there's no objection to that. And I should add, there's nothing odd or unusual about the English courts being asked to ignore claim features when considering inventive step. So, for example, it's well established that if you have a claim feature which is arbitrary or doesn't achieve anything functional within the claim as a whole, those are ignored for the purpose of inventive step. And that's the Octavis case, which is at Buttle 20, paragraphs 36 and 37. And there's another type of case known as a line in the path.
What's the page reference for that?
Sorry, it's Bundle, tab 20, page 340, 36 and 37.
340?
340
Yeah.
of the bundle.
Could I just understand, are you suggesting that the convict test should also be adopted? And if so, what happens to the Pozzoli approach?
No, my lord. My case is very simple, which is the statute requires one to identify the invention, and that answers questions about the exclusions, and then you just ask whether that invention is obvious. As long as you properly identify the invention, it doesn't matter whether one uses Pozzoli, and I'm not suggesting we should move from Pozzoli in this country at all. It doesn't matter, though, whether you invent it using Pozzoli or use problem solution or use any of the other methods that are sometimes used. You just have to answer the question of, is it inventive, once the invention inventive?
Pozzoli establishes a method of addressing that issue, as I understand it. And are you advocating for an any hardware plus Pozzoli test or an any hardware plus convict test?
Yeah.
Can I answer that? The question my lord asks is any hardware plus Pozzoli, but we don't say we say that's not a problem at all. And let me explain why. It's because
So you're advocating for an any hardware plus Pozzoli?
well, what I'm really...
Hasn't come across in the written case, but all the same.
Oh, sorry, that's what 136 is about, because it's about...
You're saying it's compatible with Pozzoli, as I understand it, but that's not wouldn't be the only way of implementing it, but it's compatible. And your suggestion is that if we wanted to, we could add an extra step 2A, which would make it more explicit how it operates in conjunction.
What I really say is actually the question of, is it any hardware plus Pozzoli or any hardware plus convict, actually is the wrong question and doesn't arise. It's any hardware which is about identifying the invention properly, plus inventive step of that invention. And whether you assess inventive step by one approach or the other, doesn't matter. As long as you identify the invention consistent with the structure of the Act, and so include all features that you should include, and you exclude all features you should exclude, you just say, is it inventive? And you can do that any way you want. And that's why it's a false dichotomy. I'm certainly not urging that we change our approach to inventive step, and that question doesn't before my lords at all. No. We just say what's key, and that's why I pointed to the dichotomy between the first two bullet points in Dunn's and the third, and also the head note in Convict, is the important thing as to law is to identify an invention and ask, does it involve inventive step? It doesn't matter how you do inventive step. Just make sure you identify the invention right. And so that's why we said we didn't need a change to solely, other than, as I stressed in 36, to make sure the invention is properly identified. And so the wording I gave to my lords was just to emphasise, make sure the invention is correct, and then you just ask, is it obvious? It is important that this just all follows from the structure of the Act. That's all that's been said. Now, if I can now go to the last point, which I think is important, and I haven't quite made the progress I hoped I might have by now, but it's really important to then look at how one identifies the features of a claim which contribute technically to the invention, and those which do not. And as I said a moment ago, G119 and VICOM kind of fit together and form a complementary pair. The essence to both is about properly identifying the Article 52 invention. The decision in VICOM is focused about identifying the invention as a whole, properly and fairly at the right level of generality, distinguishing between the claimed invention and the manner of its implementation. And what G119 is focused on is providing a more structured approach for identifying those claimed features which together constitute that invention. So to identify those which do contribute to that invention and those which don't, and accordingly including or excluding them as appropriate. If I can go to VICOM, please, and I will spend a little time on this. It's in tab 60. And it starts at page 1388. But if I can pick it up on the
page,
if I can pick it up on 1393, 1393. So at the bottom of that page, one sees the claims, and just skim them very briefly, because what you'll see is the claims are directed to methods and apparatus for digitally processing image files, and they're defined substantially by the mathematical or algorithmic approach that's taken. So it's paradigmatically a mathematical method applied using a program for a computer. Now, the application was rejected initially, and on appeal, the board undertook a comprehensive analysis of the law. And if one could pick it up on paragraph 3 on page 1395, please. If my lords could read the 3 paragraphs down to the bottom of that page.
Sorry, paragraph 3.
Paragraph 3.
Just down to the bottom of the page.
Yes, so here we're dealing with industrial application, and you see the board holds that obtaining or reproducing an image gives the invention industrial application, even where it's just a CAD design, an electronic thing. And that has some echoes of the decision of this jurisdiction, Halliburton, which concerned a method of producing a digital CAD design for an oil well drill bit, which was held to be a claimable technical invention. Now, over the page at 4, the court turns to mathematical method. And given that this is live again, if I can invite my lords to read 4 all the way through to 7 on the next page, and then I'll pull that together. So what one sees here is the board is saying the mathematical method exclusion applies only to abstract processes on numbers. But where the mathematical algorithm is used on a real-world thing, and here a digital media file, which they describe as a physical entity, then that represents a practical application of the underlying mathematical method and is not excluded. So when one's considering the mathematical method exclusion, what one is looking for is a practical application of the mathematical method, and if that is present, it will bring the claims outside of being a mathematical method as such. And then down in paragraph 8, you'll see the board makes the point that there's no objection that the claims are phrased in mathematical terms, as long as that's clear and concise and understandable. And that's what the law is in the EPO concerning mathematical methods. It's very simple, but it's important. And I'm going to come back to this at the end of my submissions. And for my Lord's notes, the law here is pretty much the same in Halliburton, which we set out in our paragraph 120. Now, if my Lords go over the page to page 1398, paragraph 10, you see a discussion of the method claims and whether they are within the exclusions. And in paragraph 10, if my Lords could read that, you'll see the way the board characterises this issue. It is asking whether the claimed method for image processing is implemented by a program run on a computer, whether that fact brings it within the exclusion. So you see the board is starting, and you'll come on to this more, but the board is starting to develop its distinction between the claimed method and the manner of its implementation using a computer program. In 11, the board notes that the invention could be implemented using specialist hardware or on a conventional computer, which obviously has parallels with the ANNs of the present case. And in 12, if I may just read it out, to stress a bit I want to stress, the board is of the opinion that a claim directed to a technical process, which process is carried out under the control of a program, be it implemented hardware or software, cannot be regarded as relating to a computer program as such within 52.3. That is, the application of the program for determining the sequence of steps in the process for which, in effect, protection is sought. Consequently, such a claim is allowable. And what the board is getting at here is the distinction between the method controlled by the computer and the computer program as a series of instructions to the computer itself. And it says the former, the series of steps in the method, is not a claim to the computer program as such or itself, even if it's implemented using a computer program. So the method can be claimed. And one sees this also, if I can take my Lord to our written case, paragraph 85, and pick it up at the top of page 52. You see the same distinction being set out in the Microsoft case, and then also in the case law, the Boards of Appeal, which is the EPO's own publication. So in Microsoft, it says the board would like to emphasize that a method implemented in a computer system represents a sequence of steps actually performed and achieving an effect. That is not a sequence of computer executable instructions, a computer program, etc. Thus, the board holds that a claim category of a computer-implemented method is distinguished from that of a computer program, even though a method, in particular a method operating a computer, may be put into practice with the help of a computer program, a claim relating to the method does not claim the computer program in the category of computer programs. That's again distinguishing between what it is the computer does and the computer program that causes it to do it. See also the case law of the Boards of Appeal. A computer program and a corresponding computer-implemented method are distinct from each other. The former refers to a sequence of computer executable instructions specifying a method, while the latter refers to a method actually being performed on the computer. So that's the same distinction. Now, if I could return back to VICOM, paragraphs 13 and 14 we can skip over because they look at novelty, etc. But if I can look at 15, which is page 1399. The 15 and 16 are absolutely key and are the paragraphs most commonly cited. And if I may just read it out and stress some points. Paragraph 15, here we're considering the apparatus claims and the exclusions as applicable to them. In view of certain circumstances by the examining division, which appear to apply to the apparatus claims as well, it remains to be examined that the present apparatus claim it would be objection under 52(2)(c) as qualified by 3 EPC. For reasons analogous to those given in paragraph 12, the board holds this is not the case, and the same applies to other claims. Generally, claims which can be considered as directed to a computer set up to operate in accordance with a specific program, whether means hardware or software, for controlling or carrying out a technical process, cannot be regarded as relating to a computer program as such, and thus not objection under the EPC. And that we see, as we did in paragraph 12 a moment ago, the distinction between the technical process the computer enacts, which is not excluded, and the computer program used to tell the computer how to do so. And that's because the invention claimed there, properly defined, and taken at the right level of generality, is the new apparatus, not the program that tells it how to act. And you see the same thing in paragraph 16, which says, in arriving at this conclusion, the board has additionally considered that making a distinction between embodiments of the same invention carried out in hardware or in software is inappropriate, as it can fairly be said that the choice between these two possibilities is not of an essential nature, but is based on technical and economic considerations which bear no relation to the inventive concept as such. So it's making the corresponding point that where an invention can be implemented in hardware or using a conventional computer and program, it's wrong to distinguish between those embodiments, because the manner of their implementation doesn't change the nature of the claimed invention itself. And that's why all this argument about hardware ANNs and software ANNs, it's where it all gets pulled together, as we talked about earlier. Now, my learned friend misunderstands that, and he misstates this in his case. If I could just pick up what he says in his 105, please. It's in bundle 100, page 103. 113. And 105, page 113.
Sorry, page 130.
113, my lord, I apologize.
113.
113.
Paragraph 105.
105. Because what he seeks to do is summarise our argument, he says, as being that if a hardware ANN avoids the exclusion, we can have our claim even though the software ANNs are within the exclusion. That's not my case at all.
You say neither is caught by the exclusion in the first place?
Yes. The fact of implementing hardware and software, if anything, just shows that the method of implementation by a computer is just not an essential feature of the invention at all, as claimed, and that's exactly what you see from paragraph 16, the first paragraph, part of paragraph 16 we just looked at. And if I could go back to VICOM, that's on page 1400, it's the second paragraph on that page, and it says, generally speaking, an invention which will be patentable in accordance with conventional patentability criteria should not be excluded from protection by the mere fact that for its implementation, modern technical means in the form of a computer program are used. And you'll understand why that says that now. And then it's as decisive as what the technical contribution, the invention, as defined in the claim, when considered as a whole makes, and then says, to the known art. Now, this is important. There's two things to note about this. Firstly, it's emphasising one has to look at the claim as a whole. And the second thing to note is, to the known art, this was at a time when the VICOM test was being applied, so that is effectively similar to the Aerotel test, you had to compare their contribution to the art. Now that we're in the any hardware world, you can effectively delete the to the known art at the end of that sentence. And just picking up on that, my lords may have noted that some of the more recent EPO cases use a slightly more nuanced language here, because they no longer apply the VICOM approach. So when considering the invention itself and the exclusions, you'll see some of the cases refer to technical character rather than technical contribution. And then they revert to the technical contribution language when they compare that invention to the art. So there's that language. And to my mind, actually it's slightly better to use the technical character language to describe the invention and technical contribution when you're comparing it to the art for the purpose of inventive step. And you see that, for example, in bullet points E and F of Dunn's that we looked at earlier. And I'd like to pick up, if I may, a couple of the English cases which we submit capture this analysis correctly. The first one is CFPH's application, and I can take that from my written case, scaled at 115, that's page 60 of the bundle.
Page
60. And you'll see it set out under paragraph 115. And you'll see there, His Honour, sorry, not His Honour, it was Peter Prescott, QC, sitting as a deputy. But he asked the question which effectively is the Vicon question, which is, the question to ask is it the artifact process new and non-obvious merely because there is a computer program, or would it still be new and non-obvious in principle, even if the same decision was taken by a little man with a control panel? So he's distinguishing between what the invention does and the computer program that enables it to do it. And that, we say, is consistent with Vicon. And one sees the same in the AT&T decision as well. And if I can invite my lords, that's in tab 22, and if I can invite my lords to turn to bundle 394, and for your note, the passage is 17 to 20, but if I can just ask you for the purpose of time to read paragraph 20, we say that is, again, a fair summary of a fair analysis. So that is Vicon. And if I may turn to G119.
It's one thing to imagine the process for canning soup being operated by what Mr. Prescott rather rightly calls a little man at a control panel, as being a way of looking at it in a non-computerized sense. It's quite another thing to think of a machine learning process being operated by an ANN outside of a computer context. I'm just having difficulty in transposing that sort of perfectly understandable image into this context.
Well, I think we'd have to have a pretty complicated control panel. That's true.
That's for starters.
Yeah.
In fact, you wouldn't have had little man at it at all, because the control panel would be teaching itself. Well,
indeed. But the point he's making is the same one in Vicon, which is you've got to look at that which the invention is doing, not the computer program that tells it how to do it. So it's again drawing this distinction between the method and the implementation of its method. And that's what you see. Perhaps my lord sees it. That Vicon sets that out very clearly, and I've shown that to my
yes.
lord. Maybe Vicon might. If CFPH doesn't help in this context, Vicon is definitely the one. Is definitely very clear about that.
Yeah.
And that's a case that's been still cited in the EPO widely. It's cited all the cases here. Now, what G119 is about is providing a structured approach for the identification of features of claims that together contribute to the invention properly identified. And what... sorry, just give me a moment. We set out in our written case at 74 through to 77 the distinction between features which are non-technical and features which contribute technically. And In fact, my lords, if you could read that, I'm just trying to find the quickest way of dealing with this, but this is really important.
Sorry, page.
It's page 49, 74, all the way through to
Thank you.
77.
Right.
And they must contribute
Technically.
to the solving of the problem.
It must contribute to the, well, one has to take the invention as a whole, and then the features that one takes into account are those who contribute to the overall invention. That's what it, and I'm going to show you that that's really key, really, really key. And the fact that a feature is non-technical in itself, so prima facie excluded subject matter, is no bar if it does interact with other features to contribute. And that's the nature of the kinds of interactions. We address this in our paragraph 88, but if I can take my lords to where G119 address this, in the bundle at page 1236. And under 1236, in 185 and 186, they describe all sorts of ways that one may contribute. So it may be technical inputs to a computer, technical outputs through direct links with a physical reality. That's 1236, my lord. Technical inputs and technical outputs that achieve through a direct link to a physical reality. And you'll recall that Vicom described the digital image file as a physical entity there. It can include adaptations to the computer or its operation which result in a technical effect, so that's a better computer type case. They can occur in all sorts of ways. And then in 88, the court says the enlarged board does not see a need to require a direct link with external physical reality in every case. On the other hand, technical features may be established for features within the control system, etc. But then 5 lines on the bottom of that paragraph says, while a direct link with physical reality based on features that are per se technical or non-technical, so in other words,
So which paragraph are you reading
sorry,
from?
I'm looking at the last 5 lines of paragraph 88.
88, right.
88. Sorry, I've jumped ahead.
Yeah.
My lord, I'm rushing. But the conclusion they make there is, while a direct link with physical reality, based on features that are per se technical or non-technical, is in most cases sufficient to establish technicality, it's not a necessary condition because it needs to remain open. So the point that's being made there is that in most cases where a computer interacts with the real world, you will have an invention that is not excluded. And you'll understand why that is. Because if your claim is to doing something using a computer which interacts with the real world, such as analyzes a digital image file, the correct characterization of that which you claim is likely to be an improved method of analysing a digital image file by doing X, Y, and Z. And that is not with an exclusion, even if for implementation of that method one is using a computer. And just for your note, the law is much the same, or at least the law has been expressed by Lord Justice Burse, at that time His Honour Judge Burse QC, in Halliburton at 32 to 33, which is bundle tab 28, page 694. And he says much the same there. He says that in general, if your computer program interacts with the real world and that which it's doing is not itself excluded, so you're not using a computer program to produce business documents which falls in business method exclusion or something like that. If that which the computer is doing, then in general, you will have a claimable invention. And the other thing he says, which is of interest, he says, and even if you don't, like in the Merrill Lynch case, which was related to a computer, using a computer to perform trades, he says you should note why that's rejected. It's not rejected because it's a program for a computer. It's rejected because the method, the improved method of making trades, falls within the business method exclusion. And drawing this all together, sorry, if I can have 30 seconds, VICOM and G119 are really directed at the same target, properly identifying the invention under Article 52, having regard to that which is claimed and the claim features as a whole. VICOM is concerned principally with the proper identification of the invention at the right level of generality, that which is claimed, and not being distracted by questions of implementation. And G119 is focused on providing a more rigorous structure to ensure that all the relevant features which contribute are identified, and those which do not contribute are properly excluded. And that, my lords, is what I was proposing to say on the law of the EPA. I haven't made quite as much progress as I hoped I had. I will take the red pen to matters.